you will know from the television, you will see the lawyers taking a very active role in telling witnesses what to say. That dog doesn't hunt. It does not happen.
What are we going to do about today?
Well, are you going to plead guilty?
No.
Have you had a chance to refresh yourself from the statements which you made in this case?
I have read, and occasionally my mind is going blank.
So I think now we'll start with the trial. So put my hat on.
Yes, would you like to call the case on, please?
The next matter in the warrant list is the case of the United States Kingdom Safety Inspectorate and MR Events Limited. The matter is fixed for trial today, and you have Mr. Campbell prosecuting and Mr. Collett defending. Mr. Woodford, if you'd like to stand up.
Just identify, please.
Can you confirm for the court your full name?
Christopher Woodford.
And is it correct that you are a director of the company MR Events Limited?
It is, yes.
Thank you. Your Honour, I believe that there's a preliminary point. May Mr. Woodford be seated, please?
Yes, indeed. Do sit down, Mr. Woodford.
Page 9 of the bundle, ladies and gentlemen.
Yes, Mr. Collett.
May it please Your Honour, I appear, as you heard, for the defence, and Mr. Campbell for the prosecution in this matter. I rise at this stage. Does Your Honour have the indictment before you? I believe it's in your bundle.
I do, yes.
Mine is paginated number 9. You'll see there are 3 counts, pages 9, 10 and 11.
Yes, I think it's page 8, 9 and 10 in my bundle. I don't know whether it is in the jury's bundle, but at any rate, counts 1, 2 and 3.
Matters not, you have the 3 counts.
Indeed.
I'm grateful.
Indeed.
This is an application, Your Honour will be familiar with the indictment rules, apart from the typographical error that one sees within the indictment as it stands,
Yes.
the missing word "and," I'm sure that could be corrected. But in my submission, Your Honour, this is an indictment that is somewhat overladen. You have had an opportunity, I'm sure, of reading the papers and will know this concerns a solitary accident that occurred on the 15th of February.
Yes, indeed.
I'm grateful, Your Honour. Your Honour, the charges that have been brought by the prosecution, and it is of course a matter for them, but it is for Your Honour to see whether or not the fairness and justice will be affected by an overloaded indictment that may prove confusing to a jury. And certainly in the form that it is currently at, I would suggest that the indictment is somewhat overloaded in that it relates to a number of incidents rather than the single incident, which is perhaps best covered by count 1.
Yes.
And therefore it's a matter, of course, for the Crown which they wish to proceed upon. But in my submission, it is something that I think is an overloaded indictment, and I think it will cause confusion, and of course, as you will be aware, that the matters contained therein are somewhat similar.
Well, they are similar, but they're entirely different allegations, and they're based on entirely different regulations, aren't they, Mr. Collett?
Well, they're based on the same allegations, Your Honour, with respect, they're simply differently worded. If you look at count 1, which
Yes.
is the contravention of section 2.1, and you can see the details set out therein, there are a number of allegations contained within the particulars of the offence, and you see that those particulars are somewhat repeated throughout both accounts on the following 2 pages. It's my submission that the regulations don't actually take us any further forward. These will be matters that would in any event fall to be considered in the same round, and in fact when a jury may simply prove confusing if one is overdoing the, as it were, the charges that the client faces.
So which of the charges are you suggesting that should be
I think count 1
proceeded with?
Count 1 simply contains everything I think the Crown is seeking to allege against those that I represent.
Well, let me hear what Mr. Campbell has to say. Mr. Campbell.
Well, I'm always grateful when the defence wants to speak on behalf of the Crown, Your Honour. I'm surprised that Mr. Collett doesn't actually want all 3 counts to be dismissed by you at this stage.
There's no need to be facetious, Mr. Campbell.
Your Honour, there's 5 points which I would wish to make. Firstly, I think that my learned friend does the jury an injustice by saying that having 3 charges in front of them somehow is complicated. It's insulting the intelligence of the jury. Simplicity is evident throughout all 3 counts. Secondly, in relation to the issue of duplicity, although I must concede on behalf of the Crown that count 1 is more of a global charge, if one looks at counts 2 on page 10, ladies and gentlemen, and count 3 at page 11, they show 2 specific aspects of the gravamen of the criminality without the jury being able to consider those specific allegations. We would say that should the defendant be convicted, you would have difficulty in ensuring that the public interest is protected, in that the full force of the law by way of a financial penalty can be imposed. Lastly, Your Honour, I raise the issue of the public interest, because in particular there is not one event here, there are three. There is a duty upon the defendant company, firstly, to evaluate an employee, secondly, if appropriate, to then train them based upon that evaluation, which of course we say did not happen. And importantly, thirdly, the issue is then the injury which was caused to the individual concerned as a result of the failings by the employer. But of course, Your Honour, it is a matter for you and your discretion. It would not be fatal to the prosecution case should you only leave us with count one, but we would submit that in all the circumstances you should not insult the intelligence of the jury and leave it as a matter for them. Your Honour, those are my submissions.
Thank you. Mr. Collins, anything in reply?
No, thank you, Your Honour.
Well, I take the view that count one on this indictment deals with a number of respects in which it is said that the defendant has failed, and particularly allowing Mr. Roper to drive the buggy without any site induction and without any relevant training. It seems to me that count two also covers the question of training. Count three also covers the question of induction. So it does seem to me that there is overkill in allowing all three charges to be pursued. And it seems to me that in the interest of justice, the correct course is for me to allow the matter to proceed on count one, which it seems to me covers all relevant matters. So that's my ruling. Thank you.
I'm obliged, Your Honour.
Can the indictment now be put to the defendant, please?
Stand up.
Or the remaining count on the indictment. Yes, please stand up, Mr. Woodford.
It is alleged in count one of the indictment that you contravened section 2, subsection 1 and section 2, subsection 2 and section 33 of the Health and Safety at Work, etc. Act 1974. The particulars of offence are that on the 15th of February 2016 at Common Lane, Cannock, in the county of Stafford, MR Events, being an employer within the meaning of the Health and Safety at Work, etc. Act 1974, failed to discharge the duty imposed upon it by section 2, subsection 1 of the Act, and that it failed to ensure the health, safety and welfare at work of all employees was met, so far as reasonably practicable, in that it permitted Mark Roper to drive a buggy without any site induction, without relevant training, and without inquiry as to whether he held an appropriate driving licence, whereby it said that the company is guilty of offence contrary to section 33, subsection 1A of that Act. To this matter, does the company plead guilty or not guilty?
Not guilty.
Thank you. Can the defendant be seated, please, Your Honour?
Yes, do sit down, Mr. Woodford. Mr. Campbell.
Just before Mr. Campbell opens, when the prosecution opened the case, you'll see defence counsel normally staring at the windows, looking about as bored as we possibly can. So the jury think, oh God, what's this man going on about? Even though the barristers are bored. Don't be fooled. I'm listening to every word he says, because if he says something and then doesn't prove it in the trial, I'm straight on it, straight onto it. Because if he said to the jury, oh, such and such, in this case, so-and-so did this, and then it comes out that they didn't, it might be a hook for me to say, well, hang on, this jury's been told something they've now been told isn't true. So whilst, as in normal cases, the defence will look, if you ever see it, go to a courtroom and see it, you'll see defence counsel staring at the ceiling, examining the nails, shuffling the papers. Don't be fooled. I'm listening to every word he says in case he slips up. I want to know exactly what he's saying and how he's going to prove his case. So will the judge. David.
So what you've just seen so far is what's called a preliminary point. Does anybody have any questions about that? Because at the moment you thought you had 3 charges to consider as the jury, and there's now just the 1. Did everybody follow, albeit quickly, and you did it speedily, what just went on there? Yeah?
Just to back up what David's saying, we are taking this at some pace by the legislation. So don't think, oh my God, you know, I can't keep up with this. We've got a lot to get through today in a fairly short time, and this sort of a trial would probably take days, and we don't have days. So don't feel the same about saying, sorry, what did you just do? So yeah.
Yes.
Would it have any bearing if he's found guilty on the sentencing?
No, because we were talking about this earlier, that what we think would probably happen, because the sentencing guidelines are the same for all three, that what a judge would probably do is impose a sentence on one count and then what's called no separate penalty, or the concurrent sentences, which means at the same time on the other counts. If there would have been a difference in sentence, so for example, if there were two charges, say there'd been a more serious injury, such as a death. So normally what would happen then is you'd have the manslaughter, corporate manslaughter charges, and then you'd have the subsidiary breaches of health and safety. Those would always be tried together. Probably the way in which the health and safety executives sometimes dance on pinheads is probably reflected. You may remember a couple of years ago, I don't know whether people here from the Leicester Tigers or whatever, Taunton, rugby, firework display, crashes on the M5. Originally charged with the manslaughter under the old regime, halfway through dropped down to breach of health and safety regulations because they realised they couldn't prove that there was any real link between the acts or inactions of the rugby club or the person who was running the firework display. Ultimately, and quite rightly, he was acquitted because the key to that case was that all the deaths and fatalities were on one side of the motorway. And it became evident from what had happened that it wasn't the fireworks, it was a fog bank which hit only one side of the motorway. Why was that prosecuted? Because there were fatalities. And there's always going to be a public interest for the Health and Safety Executive to prosecute fatalities, and always now an incentive for the Health and Safety Executive to bring prosecutions because they want to be able to recoup their investigation costs. And that's why that went there. Sorry, sir.
Count one mentions the driver's license.
Yeah.
This has to be discussed as checked. Is that for under induction?
Yes, it probably does. Yeah.
But it's a separate allegation as part and parcel of count one. I mean, the danger with the course that I have taken, of course, is that if the three separate charges were there and the jury said, yes, we find guilty of count one, but not count two, the training, and not count three, the induction, you would be left with looking at count one and saying, well, he's been found guilty on something, but it can't be to do with the induction, it can't be to do with the training. So the only thing he's been found guilty on is the failing to inquire about the driving licence, and that would be reflected in the sentence. Because I haven't done that, that's an option that's not a...
I mean, it's the other option is I could have amended count one to leave it to just that, and then to leave them all as separate individual, and that might be a better approach if I'm thinking I'm going to get a hit on one and not on others. But we've only got a certain amount of time. A lot of this will have been done, hopefully, prior to trial, so that when it, I mean, I would have raised it at the plea and directions hearing when they were setting things out. We'd have said, look, we've got an argument on this. The judge may have said skeletons.
I would have drafted the indictment that way, anyway, to begin with, because I'd rather go quick, clear, simple, rather than overcomplicate things. Not because of out of any disrespect for a jury, but actually because of a respect for them, because the problem with all prosecutorial authorities is that they come in, they take a blunderbuss approach to matters, and they're because especially in the public sector, they're so scared about making a mistake that what they'd rather do is overburden things, let a court sort it out so they can go to their line manager and say, it wasn't me, so when I have my supervision, because of the fear, sadly, within the public sector, because of redundancies and austerity, that less experienced members of prosecutorial teams probably aren't as resolute or as firm as they'd like to be, and things end up being long-winded investigations when actually they could be cut off quite early by agreement with a potential company. So, yes?
Short answer.
That's right.
If it's a short
right.
Why are you being prosecuted under section 30?
Purely, we're only this is merely, there's plenty of reasons why we could do loads of other different things. We thought this is the simplest way to do it because it's not about guilt or innocence here. It's about showing the modus operandi of the way a trial works. And there are many things within this case which, if we had a proper 4-day trial, my learned friend here would be taking a point with. There's many criticisms of the Health and Safety Executive, there's many criticisms about the way the defence is done, criticisms of the company, but it's just basically, we want to show you a flawed case. Because ultimately, this is about not courts of law, it's about what can ultimately happen if you don't get it right at the beginning. If you don't work how you instill into your companies and your organisations a top-down approach to the way in which health and safety is done. Because it's like, for want of a nail, the shoe is lost, for want of a shoe, the horse is lost. And you see, out of a little minor thing, you end up having a company not only facing the prosecution and the punishments there, but spending the money in legal fees and the money spent in the time and the resources defending it. For the moment health and safety inspectors come along, time. So instead of getting on with that core business, running events, rugby teams or whatever, they're spending it in lawyers. The last thing you want to do is have to deal with a bloody lawyer. And so it just shows you that if you get the systems in place to begin with, and you get a way of a culture within an organisation, you never have to come here. Health and safety turn up and they go, thank you, it was an accident, you did all you could, bye, end of. But instead, by failings in the company and failings within the organisation, left themselves open to, well, that's the point, allegedly. They only need an allegation to be able to run that, and to your companies and the people who you look after have to face all this. And this could be 3-4 years after the incident. And actually, that's not what your company should be doing, or your employers, or your own businesses. You should be getting on doing what you're good at, and not having to deal with lawyers. So, we will begin.
Just to say, it's money well spent here, all right?
Oh, that's it. Now, the opening is always done by the prosecution. Defence are sometimes entitled to an opening speech, but don't tend to do so. The prosecution are entitled to a closing speech at the end. Gavin and I and his honour here are old school, so we were actually taught and practiced what I would say the proper way. Now we have an abundance of Tesco prosecutors, where they, well, sadly it's like you wouldn't send them to a post office to get a dog licence. Because time is short, you have in your bundle, and it'll probably be of assistance to you, if you turn to my page 14, those are agreed facts. Now when you're working with your lawyers, sorry, I've got it at page 14.
I think it may be page 13. Page 13.
Yeah. I was going to say, I think we've lost a page.
Well, it's called agreed facts, yeah? You see them there. There might come a stage in the preparation of the case where lawyers will come to you and say, the prosecution have asked for some admissions. And you go, I don't want to admit anything. Again, this is back to the case management about saying, hang on, what's in dispute and what is not in dispute. When all this sort of stuff came out, it's used more and more nowadays, us old crusty lawyers were a bit against it, because we like the theatre and the idea that everything should be up for grabs, you should throw it in the air and see where it all falls. It's actually really useful, because it allows you, as part of the case, and for speaking sexual part of the defence case here, it's your company on trial, to realise what you need to worry about and what you don't. And so there might come a time where your solicitors or your insurance company will say, do you agree this, do you agree that, do you do that? And it's never going to be an admission, which means that you've got to stick your hands up and go, I'm guilty, but it's all about assisting the court process. For the purpose of this morning, I'm not going to go through all those with you, you'll be pleased to hear. Then turning back to page 4, let's check, has everybody had a chance to read this beforehand? Who hasn't? Right, so then I will have to speak.
Open it.
That's fine, I'll do a bit more of an open then. Make please your honour. Members of the jury, I am here on behalf of the Crown in this case, and my learned friend Mr. Collett appears on behalf of the defence. We bring this case, and it is our duty and the burden upon us to prove the case. How do we prove it? We don't prove it, members of the jury, by speeches from here, nor indeed do the defence explain their case by lengthy speeches from defence counsel. We prove it by evidence. And the evidence you will hear in this case will come in two forms. First form will come from the witness box. The second form will come through statements which are read to you. And once you've heard that evidence, members of the jury, we'll be extending an invitation to you to convict this defendant of the charge which you've just heard. What do we need to do in order for you to be satisfied that you can find this defendant guilty? Well, you must be satisfied so that you are sure of his guilt. That is the same as saying, members of the jury, a phrase which you will have heard of, that we have proven beyond a reasonable doubt of his guilt. And we will submit to you that you will be under no illusions that once you've heard the evidence, rather than the speeches in this case, or even anything from the learned judge, that you will be able to convict the defendant to that standard. Well, members of the jury, we're going to take you back now to an incident which took place on the 15th of February of 2016 at Common Lane in Cannock. You may be familiar with that area. On that day, an event was taking place, and we say that the people who were running that event, MR events, failed in their duty to properly ensure that their health and safety practices were adequate. So much so that as a result of their failings, their criminal failings, an individual suffered a fracture to the hip. We say to you, members of the jury, that the case is commonsensical. This is a business with resources. This is a business with employees who have responsibilities. This is a business which should have known what it was doing. This is not, as the Daily Mail or Richard Littlejohn would say to you, health and safety with a capital E. This is bog standard common sense, because we say that when you employ someone to drive in this place a buggy, it is wrong and it is criminal for you to allow an employee to drive a buggy when they don't have a driving licence, they haven't been assessed as to whether or not they know how to drive a buggy, and that they know what their responsibilities are and how they should perform the operation. Now, there is a culture nowadays in society that we as the prosecution, the health and safety executive, get ourselves over-involved in the minutiae of how you should run a business. There is feelings amongst some that actually just let businesses be business. Well, no, members of the jury. We say to you there is a lie. And that's all well and good that businesses should be allowed to run themselves adequately. But they cannot do so ignorant of their responsibilities to others. And in particular in this case we say that as a result of this company failing to even ask their employee what his abilities were, failing to explain to him what his duties should be, failing to check that he knew what he was supposed to be doing, someone suffered a severe injury, namely a fracture to the hip. That's the real point of health and safety for members of the jury, because of the fact that members of the public and individuals can be injured and put out of work as a result of people playing fast and loose with what basically are common sense things here. We're not saying that this company should have spent millions of pounds. We're not saying that they needed some newfangled technology. All we're saying is this: if you are an employer and you have someone come to work for you, you find out what their abilities are. If they are deficient in their abilities, you train them properly so they do no harm to anyone else and no harm to themselves. It is as simple as that. And anybody who seeks to persuade you that this is the nanny state trying to impose its will upon Mr. Struggling Entrepreneur, members of the jury, ignore that opinion. Because the only thing which need concern you is this. Did they fail? Why did they fail? Were those failures a breach of the law? We submit to you, members of the jury, when you've heard the evidence in this case, you'll be satisfied so that you're sure that it's safe to say it's beyond a reasonable doubt that this company failed and therefore are guilty of the offence. And therefore, Your Honour, with Your Honour's leave, I call our first witness, Mr. Mohammed Basharat. You'll also note that it doesn't appear in the evidence that he ever offered Mrs. Hugh an opportunity to sign that notebook as a true and accurate record of the conversation.
When you visited the site on the 15th, how many members of the public were present on site?
Just the employees of the company who were working.
That's not a member of the public. How many members of public? So not employees, how many members of the public?
I'm afraid you're going to have to rephrase your question. I just don't know what you mean.
I think the jury got it. If you didn't understand the
Well, that
question,
it was
don't know.
satisfactory, yes, of course they understood that it was satisfactory. It complied with the legislative requirements. Would that be helpful, sir?